Thank you for joining us for the webinar on the new AIA Owner-Architect Agreement. We'll be talking about mostly the B101 2017 agreement, but we'll look at some of the other ones too. And remember, a month from now we have another webinar on the new AIA agreement where we'll focus mostly on A201, the A-Series Owner Contractor Agreement, and the new insurance exhibit that goes along with that. Just some background information. My name is Frank Musica. I first got involved in the AIA documents back in 1976. I've been working as Schinner's representative on the AIA Documents Committee since 1991. I'm not the first person to work with the AIA Documents Committee. In fact, Vic Schinner himself, 6 years after the program started in the 1950s, became insurance counsel to the committee in 1963. And if you look at the copyright dates on the documents, you'll see that there were quite a few changes in 1963, 64, and 65. Part of that was Vic Schinner bringing information on claims, lawsuits against architects, and they had an impact on the language of the AIA documents. As you know, this has been filed with the AIA CES system. It's 1 hour health, safety, welfare qualified. If you're an architect, you've already given us your number. If you're an engineer or other, you've probably checked for a certificate. That will be taken care of after. This program, by the way, will be on our website under our webinars, so you can download it, listen to it, or have other people in your firm listen to it later on. That's the official information the AIA asks us to provide. The learning objective, we're going to focus mostly on the discussion of B101 and some of the provisions that were retained from the earlier documents. We will mention the Sustainable Project exhibit because I think there's a great history behind that, the E204, but we won't go into that in detail. We will be doing other publications on our website, available on our website, on all the AIA documents, including the Sustainable Project exhibit, and how it's supposed to be used and what it means to architects and contractors on projects. Now, you should know the AIA publishes hundreds and hundreds of documents in various families. They're really based on what's needed and you know, the project type, the client type, whether it's design build, whether it's some other form of project delivery, whether it's a national project, international project. So the scope and the complexity of the documents really depends on project type, client type, and project team. We'll talk about some of the owner-architect agreements, but we will only go into detail in the first one. Now, you know, that's what this 2017 series addresses. It really looks at the traditional documents in the family of design, bid, or negotiate, and bill. You know, you may know that the documents really are updated about every 10 years. So there was the 2007 documents, and now 2017 that were introduced at the AIA convention last month. The release this time includes 11 revised AIA forms and contracts. There will be another 18 forms and agreements released this fall. They are more or less the follow-on agreements. The AIA Document Committee meets next week. Final approval will be given to those 18 forms and agreements, and they'll get into the process of being added to the contract document system where you can obtain them electronically, and some of them will be in printed form. You should know that if you're using the 2007 documents, they will stay in the system and can be used for up to 18 months. After that point, the family of documents will be withdrawn, which means their copyright copyrighted documents, and you cannot use them after that point. But there is this 18-month transition period. These are the ones that really work into the traditional design bid build family. Again, we'll be looking mostly at the B101. There are others, the 102, which really was a carryover from the 1997 agreement. What used to be Part 1 of B141 is really just terms and conditions. It's where there's no predefined scope. The B103 has been updated. The first time it came out was 10 years ago. It was a document prepared for mostly very large projects, complex projects. It was actually demanded by many large architecture firms. And it looks at things like having an outside cost consultant and other players on this complex project. The B104 is an abbreviated form. It only has 3 phases of service rather than 5. The B105 cuts it down even further to 2 phases of service. Those are good documents for very simple projects. I think many architects base their own documents on the language in the B104 and B105. Not a bad way to do it, but they do not provide the kind of protections for the architect or really provide the clarity that a B101 provides. There are other AIA documents as well, of course. The that's B106. That's for pro bono projects. There's other ones that have been published in past years that are still useful, and that's the the ones more for housing. Both the pro bono and the developer builder agreement were published in 2010. The federally funded or federally insured projects one came out in 2008, based on the 2007 documents, and the B109 came out in 2009. And of course, then there's other documents for program management services or design build services. The design and build documents came out in 2014 and made a major change in how architects work on design build projects. Let's talk about B101. Let's go right to the beginning, and that's the initial information. In the past, this was an exhibit. That did not work very well. Over the last 10 years, when they documented how firms were using the documents and documented complaints from firms, they found that often the information that should be in that exhibit was never completed. And that made projects more difficult because you need to share the information. You need to know what basis you're using when you're designing the project. So now all that information is actually incorporated into Article 1. So there's a lot of fill-in-the-blank type areas. Right? The history of the sustainable objectives, if you know, when after the 2007 documents came out, the AIA came out with a publication that really dealt with sustainability. It was an advisory publication called B503, and it had some language examples in it. They then, that came out in really 2011 in detailed form. They later it came out with sustainable project versions of the other documents with the idea that you would use one when the client did not come up with a sustainable objective, and the SP documents when it was a major part of the owner's concern. That did not work very well either, having dual sets of documents, parallel documents for all the owner engineer or owner architect, architect consultants, and owner contractor agreements. So this time around, they really took a different approach. So instead of creating SP versions of each agreement in the family, they looked at having this sustainable project exhibit. And if you have a client who is interested in sustainability objectives, LEED certifications, or any other sustainability objective, you really attach this document, the E204, to the contract. And it sets forth all the roles and responsibilities of each of the project participants, really as they relate to the unique elements of the sustainable design and construction. So this gets attached to the owner-architect agreement, and it gets attached to the owner-contractor agreement. So everyone has the same understanding of what's needed for this project. The standard contracts have some reference to electronic documents in them, but the AIA developed early on a set of documents to deal with BIM and to deal with digital practice in general, and that has evolved over the years. I think initially they came out with E201 back in 2007, along with the B101 documents. And over the years, they've changed those, they've modified them. They're 2008 ones. And in 2011, they came out with the current ones on digital data sharing and all that. And then for this one, they came out with the E203 2013 edition for building information modeling and digital data. And it sets up the initial agreement of the parties, and then it's modified as you go along. And there's protocol documents in the G series that help outline what specific information is being exchanged and how it's being exchanged. So that sets up the document. Article 1 sets up the relationship. Article 2 talks about architects' responsibilities, and there's some minor changes in Article 2. One thing, and I think this was requested mostly by owners, is it says that the architect will either be licensed to perform the services in a jurisdiction, or will cause the services to be performed by an appropriately licensed design professional. Now, I think that makes owners happy. I'm not sure it makes registration boards and states happy, because in addition to licensure, there's other things that firms have to meet in order to practice, in order to even hold themselves out as architects in some states. But this does at least meet their requirement that if I'm not licensed in that state, someone licensed in that state will be in responsible charge of the project. There's two things related to insurance in Article 2 that we were happy to work on with the AIA. As you know, Article 2 talks about some of the insurance the architect should carry. They added two things to it now, which I think were basic to the ability of the architect to provide insurance that the owner wants. And one of them was about additional insured status. A lot of owners are confused about that. They ask to be named as an additional insured on the professional liability policy, which is not possible. And if they were, it would basically deny any coverage for any claims by them. So the Documents Committee added to Article 2 an additional insured obligations provision that clearly applies only to the CGL coverage, the general liability coverage, and the automobile liability coverage. And because owners want certificates of insurance, they just added a provision that says the architect will provide a certificate of insurance to the owner. And by doing that, they wanted to head off some of the requirements that owners put in that insurance companies often cannot meet on notice of changes in the policy or erosion of limits in the policy and other things that just do not make sense in a professional liability setting. The scope of services kept the traditional 5 stages of service. They added a little bit more language, and part of it in 3.1.2 is the language that always said that the architect could rely on the accuracy and completeness and timeliness of anything provided by the owner or the owner's independent consultants, when owners often hire mechanical or electrical or others themselves. This time they added the language and shall not be responsible for. Is that really necessary? Probably not, but I think it makes people feel a little bit better about that they're not going to end up having vicarious liability for consultants hired by the owner. In addition, in 3.1.4, they made it clear that if the owner accepts non-conforming work, the architect has no responsibility for that unless the owner asks the architect to give written approval, in which case you're doing that as an additional service, you're analyzing it, and then you can or cannot give written approval to it. If you do that, you will have some responsibility for it, of course. Again, it updates the approach to sustainable services. We'll talk about additional services and supplemental services a little bit later, but the work you do related to sustainability really ends up bringing in more money as a supplemental service. Now, you still have to consider sustainable design alternatives, which all of you do now anyway, because I think that's part of the standard of care. But if you're going to do more services related to sustainability, this gives you the ability to get paid for that. Also changed what the construction phase documents are for slightly. And again, this is another one where owners really wanted to get a little bit more on what the architect is providing. So now they've added and performance criteria, materials and systems to what the architect is providing. Again, that's not a major change. When you came up with the outside design services, often performance criteria was part of how you required the outside design services. Again, other things in Article 3, the scope of services, it just renamed the bidding or negotiation phase to procurement phase services. That was thought of as being clearer and not changing really the liability of the architect in any way. Things like consideration of substitutions, if they're allowed during the procurement phase, right, during the bidding phase, basically, there's extra money that's available for that. I think one of the disclaimers that has proven to be very effective throughout the AIA document use from the 60s on was the disclaimer of construction means, methods, techniques, sequences, and procedures. That's in the documents in a number of places, including where the architect is going to be reviewing the information provided by the contractor's outside design professional. The services are limited to really reviewing it for consistency with the design concept, not looking at it from a substantive standpoint. That's in 3.5.2.3. And again, the architect can then rely on and take no responsibility for the accuracy of the information provided in the contractor's design submission. And again, I think that clarifies things a little bit more than the 2007 document. Article 4 was a significant change in that there was always confusion about additional services. In the past, for those of you who have some history behind you and using the AIA documents, you probably remember that there were things called contingent additional services and additional services. And the difference being the contingent additional services were required by law. It's required in reacting to what a government agency requires, or otherwise what's going on in the project that requires you to do a certain level of service beyond the basic services you negotiated. This time around, they wanted to, they'd gone back to just calling everything additional services, but they wanted to differentiate additional services for which you negotiate up front. So they're not considered basic services, but they're other things you do for the owner and for which you should be paid separately from basic services. Separating that scope of service out from the true additional services that arise during the project. And part of the way they did this is through a table in the documents. If you're used to the B101 2007, where it had all the additional services, there was one table, and you checked off what the service was, who was responsible for it. But they wasn't sure when that service happened, whether it was part of, in addition to basic services, or whether it was necessary because of the project. So one of the changes they wanted to do was to separate out the B101 2007 additional services into these two groups. Supplemental services are the ones that are not included in the basic services, but that the architect agrees to provide at the time the original contract is negotiated. So you go through that table and decide what other services besides the basic services you'll provide for the owner, and it even includes space for those services the owner has to provide. And then the true additional services that change from the B101 2007, they scraped away those true additional services in the 2017 document. So the additional services, as they're referred to in 2017, are the services that are really necessitated by circumstances during the project progress, right? And that could be things like the situation where a code official all of a sudden changes their mind. You know, there's been many cases where code officials will inspect a project and say, oh, we must have missed that before. This needs to be redesigned. This needs to be rebuilt. And code officials have that right now to protect public health, safety, and welfare, and they can change their minds. In the 2007 version of the B101, the architect was required to respond to changes made by code officials during the design of the project, which left open any changes made during the construction phase to be negotiated as additional services. And that led to, I think, a lot of disputes, a lot of problems. So they wanted to clarify that. And by clarifying it, they said, okay, if this comes up, if a code official changes his or her mind, and it is something contrary to an earlier interpretation, and if the instruments of the service otherwise meet the standard of care, in other words, this isn't a deficiency in the instruments of service, this isn't possible negligence on the part of the architect, but it's simply something that now is being changed, then the architect deserves more money for responding to that. And I think this will probably reduce the disputes, probably reduce litigation. We monitor that very closely. It will take years before we find out whether or not this helps to clarify the situation. But I think it's a very good start in doing so. Now, Article 5. This is the part that lays out what owners are responsible for. And it has been changed that much. There's been some changes to update the idea of what a sustainable project is, how the sustainable project exhibit is attached, and what that means for services that are supplemental right? The additional services at the time the contract is negotiated, supplemental to the basic services provided by the architect. Again, this is a way to help architects be able to identify the basic scope of service that they're doing and the supplemental services for which they should be paid in addition to basic services. There was a change that may cause problems. It was really being pushed by owners, and depending on how it works, may be okay, but we're going to monitor this very closely. And that is, owners have been asking that they be able to contact contractors directly. Now, you probably know on many projects they do it anyway. They're out there, or their representative is out there talking to the contractor, and often the architect doesn't hear about it until later. Maybe doesn't hear about it until a claim comes in because the contractor and the owner's representative have been discussing something, and both of them agree that it's deficient services provided by the architect. So this time around, they decided, okay, owners, you can talk to contractors. You don't have to go through us as your representative. You don't have to go through us as the person who's going to be on the site for you. You can talk to a contractor directly, but you need to make the architect aware of any communications between the owner and contractor. And if the architect is not aware of those direct communications, it is thought that that will keep the architect somewhat insulated from the kind of changes that might occur, or some other problems that might end up happening when the contractor and an owner communicate directly. Again, something pushed by owners, something agreed to by the documents committee. We'll see how this works going forward. It may end up providing more problems, but if, in fact, the owners are required and do make the architects aware of it, it may give the architects an out on some changes made between the owner and the contractor. The cost of the work was modified somewhat, and it really addressed two issues that I think have been hanging out there for a while. And one is that owners, in many cases, do some things by themselves, or they get things supplied to them. And in fact, one of the examples of this is on a sustainability project where many vendors will gladly donate some of their sustainable project materials and systems to an owner to get them incorporated in this, to be able to show off to others that that's what a sustainable building project should include. And what was happening is that increased the cost of the work, essentially, but reduced to the architect the amount of the cost of the work for which the architect would get a percentage fee. And that was happening with everything from the USGBC headquarters to other projects. And it seemed unfair to architects that because the owner could either put money in by themselves rather than through a contractor, or could accept donated materials or donated labor, that the architect would not be paid the same way. Now, percentage fees can present all kinds of problems, including problems of misrepresentation, fraud, and other things as well. This was one way to try to protect the architect from an owner getting around paying an adequate fee for the architect by having donated materials or services subtract from the cost of work. So now it's part of the calculation of the cost of work for which the percentage fee would apply. Again, that's a way to try to keep architects who are working on a percentage fee basis from being shortchanged. An issue that came up really quickly after the 2007 document and has been addressed in the 2017 document is what happens if the bids come in over the budget. And if you look at the documents, it's been in 6.6.4 for a while. If bids come in over the budget, the owner has a lot of options. And one of the options is for the architect to redesign, to try to bring it in within budget. Under 2007 language, that was done at no cost to the owner. And that created some problems. The reason it was done at no cost to the owner was it was considered a trade-off, because part of that language also is a limitation of liability. And it limits the architect's liability in that kind of situation to redesign. If you did not have that limitation of liability traded for the redesign services, an owner could easily sue the architect for delay damages, for increased financing costs, for any number of problems that having to redesign the project could create. So you expected this to go out to bids and the project to start at a certain time. Bids came in much too high. Architect redesigns. While architect is redesigning, material costs go up again. Contractors are busy on other projects. Bids come in high again. You redesign again. And it was a very difficult situation to be in. As material costs started going up again, it could be seen that that could create a major problem for architects. So rather than doing it the 2007 way, where you would redesign at no cost, you now actually get paid for redesigning if, in fact, that the bids came in too high because of market conditions that the architect or the owner could not reasonably anticipate. As you know, right now, steel prices will be going up. Most material prices will be going up. The cost of labor is already going up significantly. Now, can you reasonably anticipate how that would affect the project? Not really. That information is spotty. That information changes all the time. So if you're under the B101, if you're designing to a budget, you're doing an early cost estimate for the owner based on historical information, and the bids come in too high. Under the old system, you could end up having to redesign and redesign and redesign. There was no limit on how much over the budget the bids had to be, or how often you had to redesign. So this is to really address some of those issues. Now, other contracts do it in different ways. The standard engineer's contract, for instance, says yes, the engineer will redesign at the request of the owner, but at no profit. So they get paid for their services. They simply don't make a profit on that. And the idea was that if you made a profit, the owner could challenge you by saying, look, you did this on purpose, you would get more services, you would make more money. So the engineers basically have said, okay, we will redo it at our own cost. You pay us for our cost, but you do not pay profit. The AIA decided this should just be an additional service. This is not unusual. If you look at the Federal Acquisition Regulations, this language has been in there for decades now. So the design within funding limitations language says, you will do this if you have no control over the bids as an additional service. Some of the other provisions that have not really been touched, Article 7, which deals with copyrights and licenses, that setup was very carefully, I think, handled in the 2007 edition, with the idea that ownership doesn't automatically transfer either the ownership in the documents, instruments of service, or the ownership in the copyright to the design of the project. Do not automatically transfer. And it set up a licensing provision that really gave owners many of the same benefits that they wanted when they ask you to do this as a work for hire or put something in their contract that says, we get everything that you create. Problem with owners' provisions like that is it often says, we get everything you create immediately, and often it doesn't say anything about having to pay for them. And the alternative, the retention of the information, the copyrights, the ownership of the documents, and the architect makes some sense. That's not a professional liability issue. That's not even an ethical issue in most cases. It really was put in there initially as a leverage issue to make sure architects could get paid for what they do. So the licensing agreement allowed the architect to retain control, but the owner to accomplish what the owner wanted, be able to use the documents for maintenance or renovations in the future. The only change in that they saw necessary this time around was to make it clear that that arrangement survives the termination of the agreement. And we'll talk a little bit about termination later and about the termination fee and the licensing fee that goes along with that. But it was a way to make owners know that there isn't the ability for the architect to say, wait a minute, this contract is terminated, therefore that provision is terminated, and you no longer have any license or any ownership. The claims and disputes provision was pretty much left as it was. We'll talk a little bit about choice of laws later. About the only thing in Article 8 on the claims and disputes is that what happened in 2007 is there were checkboxes. And it basically said, look, you're going to mediate first, and then you can go to whatever you want. You can go to litigation and you check it off, or you can go to arbitration if you check it off, or you can go to other. I'm not sure what other was, and I'm not sure we ever have seen a contract with other, but you had these checkboxes to fill out. Problem is that many times, many contracts, no one bothered to check what the alternative was. And that's fine because most things are negotiated settlements between owners and architects. They don't go to arbitration, they don't go to litigation. But they wanted to make sure that if you don't check a box, it was clear what happens next. It was decided that what happens next should be litigation. And you may say, insurance companies probably hate litigation, we hate litigation. That's not really the case because almost nothing in a professional liability claim ends up being litigated all the way through to a final judgment. Most things are negotiated out. So by making litigation the default, if you don't check litigation or arbitration or other, what they're really saying is, okay, that gives you a chance to continue the negotiation without going into a form of adjudication such as arbitration, which is final and binding. Again, that just cleans it up, makes it a little bit easier when you have checkboxes that people don't bother to check. The termination or suspension of services provision has some changes. It really continues the fact that if you're terminated for cause or for convenience, that there will be some termination fees that you get. And that's basically the reimbursable expenses that you've already paid for, the past fees that perhaps haven't been paid yet, and the costs attributable to termination. And by that, they really mean the cost of things like, how do you get out of a contract with your consultant? what other costs like that might be, throughout the process, that the termination would cause that expense to occur. But what it does do this time around is it deletes the whole definition of termination expenses. And I think what was clear from looking at comments by architecture firms and the experience of the many architects who serve on the documents committee is that the whole idea of termination expenses as they were defined in the contract just wasn't working. That one of the first things that would happen in the contract negotiation is that part would be scratched out. We're not going to pay you all these costs for termination. We don't know what they are at this point, so we're not going to accept that language. So that was replaced with a negotiable termination fee, with the idea that if you're negotiating with the client, you pretty well know what the client is thinking. You know if this is a client who you want to work with and wants to work with you, and if that's the case, then a termination fee is something that they may be willing to put in there as a number because they really don't see that as happening. If you're working with another kind of client who may try to fund a project and then find out they can't and terminate it, you know whether or not that client is the kind of client who might stick you with unpaid fees and other expenses. So negotiating a termination fee right up front puts the client on notice that you're a smart business person, that you're not just going to let them whip you around and take away the project at the end. That is not the only number that has to be put in there. A licensing fee has to be put in there. And we talked about the ownership and use of documents before. There was the concept of if the project is terminated, you can license the use of those documents so that 5 years down the line, when they want to take that project off the shelf, they can do that. And many architects had standards within their firms where they would say, okay, I will license the use of these documents in the future, owner, if you pay me, for instance, half of what you owe me for the rest of the project. Or they had some calculus to come up with a number. And this just puts it right up front. If there's going to be a termination of the contract, what does the owner have to pay to be able to use those documents in whatever form they're in at that point? You put that right up front. You negotiate it along with the termination fee and your overall compensation. They added one thing called a automatic termination date, which doesn't do anything other than saying that unless otherwise, this contract will terminate 1 year following substantial completion. Throughout the contract, there's language about when your construction phase services start, that they start with the bidding and that they end with a certificate of final completion. Often projects don't have final completion or a date of final completion, but they almost always have a date of substantial completion because you're not going to use the project unless you have a date of substantial completion. So tying the contract to 1 year following a date of substantial completion at least put an automatic cutoff to that contract relationship, which means usually that in those states where statutes of repose are tied to completion of services rather than substantial completion of the project, this tells them that 1 year after substantial completion, that's it. That's when you start the clock. Again, it's just a matter of trying to come up with one way to make it clearer when the architect is finished with the contract. In some miscellaneous provisions, some changes, mostly those that lawyers like. One thing is over the years, they've often looked at what law governs this contract. And that's an important decision that architects and owners should make. Because obviously the law of some states, certainly things like statutes and repose, may be more beneficial to the architect or to the owner. Many owners simply say, I want it in my state because that's where my law firm is. But the idea was that, okay, let's make it neutral. Let's make the law that governs the contract the place where the project is located. And that seemed like a fairly acceptable way to do it. One of the concerns the lawyers have raised is that, well, that's fine, but many states will apply the law that might, you have two parties from one state and a project in another state. That state where the project is may apply the law of the states where the parties were from, because there's a choice of laws provision in most states. So this was to do away with that. So it's clear that if you're saying the project is going to be governed by the law of the state where the project is physically located, you know that it's that law, and the lawyer knows that it's that law that will govern your activities. The assignment to a lender has been changed, and that I think is a very good change. Lenders won't like it. Owners probably won't object to it right away. But that requires the lender to cure any defaults. And if you know when you sign consent to lenders or you're certified to lenders, your role on a project, lenders will often say, we will pay you going forward, but if the borrower owes you money for your past services and hasn't paid you, that's not our problem. And they're saying that because they probably already lent the money to the owner, project owner, who hasn't paid you. They don't want to pay twice. This says, no, it can be assigned to a lender. The lender has to cure any deficiency in payment of the fee, right? So if there's a default by the owner, the lender has to cure that default. The confidential and business proprietary information, which I think is still not quite up to what is expected in a professional service relationship, has been changed somewhat. And about the only change is if you need to release some information in the process of your defense, you can do it. Many owners understand that. It's the kind of provision that often gets changed in contracts so that you do not have to keep confidential information and harm yourself in your own defense because of that restriction. And many courts say, look, if that's necessary to defend you, that is no longer confidential information. And I think the AIA contracts just try to go along with that idea. And there's also a severability of contract provision. All that's called a savings provision. And it means, okay, if that state law invalidates one part of this contract, the rest of the contract can be carried forward. Standard in contracts hasn't been in the AIA contract. They added it this time. The compensation part clarified the progress payments, and this is silent in past contracts. One of the concerns is what happens when, for instance, the cost of work goes down. Right? And that has happened during the recession where the cost of the work actually went down. All of a sudden, the architect who was expecting so much money based on the cost of the work is going to get paid less. Same services, being paid less, simply because it was based on the cost of the work. So that this language really puts a floor under that, and says that you can't go back and readjust payments, and you can't reduce the payments because of a change in the cost of the work. And one thing that was added to the compensation part, even though it really deals with the insurance that's earlier, but they wanted to put it clear in the compensation part, was that if you're required to have limits or other insurance coverages that you don't normally maintain, the owner will pay for it. And many times it's an owner who are saying, you need significant cyber liability coverage. And you say, we don't have cyber liability coverage. I see no need to pay for cyber liability coverage. Article 11 says, well, now that's something you can ask the owner to pay for. Or if the owner wants a specific additional limit endorsement on your policy because they want more per project coverage for their project, and that costs you money, this is a way for you to collect that money. It's 11.9 under the compensation. Let's talk a little bit about the B101 and B103. B103 was the one that was put in first time in 2007. It was meant for complex projects, and it has a lot of information in it. It talks about what basic services can include, including things like multiple bid packages, phase construction. Again, this is for the more complicated projects. The B103 has cost consultants and scheduling consultants that the owner would pay for and that the architect can rely on. And all that has stayed about the same. The two documents are getting a little bit closer together, but the B103 is still for more complicated projects. One of the things that doesn't appear in any other AIA document, but does appear in B103, is a standard indemnification provision. Because large firms have said owners always want an indemnification provision. We want an indemnification provision that makes sense. We do not want something developed by the owner's lawyer that would then we'll have to negotiate to try to make reasonable. And if you're looking at a contractual indemnity agreement, using the language out of B103 probably makes sense. It specifies that there's no duty to defend the client, and as you know, in many states, there could be an implied duty to defend the client, even if it's not stated. So it specifically says that there's no duty to defend the client. And it says we will indemnify you only for harm caused by our negligence, acts, or omissions, which is what the law says in every state. One of the things that got a lot of criticism after 2007 was the idea that that indemnity was also a limitation of liability. And it was a limitation of liability because it said, okay, we will only indemnify you to the amount of our insurance coverage available. That was modified somewhat because owners said, well, wait a minute. You can have other claims against you on other projects that erode your limits. What you're telling me is that you could even walk away from your insurance and say, I'm not going to indemnify you because I don't have any insurance available. Now what they say is that if the contract states what the insurance should be, what limits should be, and that's the extent of your indemnification. That makes sense. That's a de facto indemnification limit anyway, and it keeps this from being thrown out in many states. There's a number of provisions that were retained from 2007 that I just wanted to point out to you because they are very protective of the architect. And many architects say, well, there's not this limitation of liability in the contract. There's not this provision that protects me. There are limitations of liability throughout the AIA contract. They withstood the test of time, and these are some of them that make sense. The standard of care definition is what any jury would be given as the standard of care to which you'll be held. So it's not a guarantee, it's not a warranty, it doesn't elevate the standard of care. Reliance on the owner's information, that helps. The work disclaimer, probably one of the most important limitations of liability in a contract because it prevents you from being held responsible for means, methods, techniques, sequences, procedures, and site safety. the architect under the B101 that you will have you will stand between the owner and the contractor in giving your opinion of what should happen in the claim from a contractor. And there's a quasi-judicial immunity for doing that. And that's in the contract. There are other things like what you do with shop drawings and submittals, and of course, a limitation of liability in the redesign situation, and of course, the waiver of consequential damages. Something that was added in 2007 has met with some resistance by owners, but tends to be left in a lot of contracts. Owners often resist that because they know it is rare that an architect would ever have the ability to go after the owner for consequential damages, unlike a contractor who has that ability. So even though it's called a mutual waiver of consequential damages, it really benefits the architect. And consequential damages, if you can have the owner waive their right to go after consequential, special, incidental, all those other damages, and rely on just direct damages, it will help you in the long run. It will help your insurance company in the long run as well. So those are some of the provisions that are in the 2017 edition. They were held over from 2007, and you should be aware of them because they are very important in limiting your liability. Now, one thing you should know is even though the AIA sells documents and sells the electronic system, you can get free samples of the new documents. Go on the AIA website, fill in the information, you can get a free sample. And you can also get some other documents with no charge at all. And one of them is the B503. The B503 is updated every so often, although it keeps an old copyright date. It's updated, and it provides guidance and model languages on any number of issues. When we worked with the AIA on the new issue of materials transparency, we worked with the Institute Documents Committee to come up with 3 alternatives in dealing with materials transparency. When the firm wants to promote it, when the owner wants it for something like lead points, or when the owner wants it because they have some real concerns over what's in their buildings, and there's some examples of language you can use for that. So there's a number of things in the B503 that you should be aware of. It's a free document. It should be in your system and looked at all the time. Now, as I said, we will be publishing stuff on the B101, on the A201, on some of the other new documents. They'll be available to our policyholders on our website, as will this webinar. It will take about a week, but it will be under webinars on our website. So don't forget to go to thatchinner.com AE Risk Management for more resources. Again, if you've already given us your information, you will get a certificate, or you will simply be reported directly to the AIA, and you will get the 1 hour health, safety, welfare credits for this course. Normally, we ask for a lot of questions. Unfortunately, because we are tight on time, we will not be able to answer those questions. But if you do have a specific question, again, look to our website, look to our blog. We will be answering a lot of those questions that way. And then there's always a thing on our website where you can ask additional questions and we will respond. Whether you're negotiating a contract or just looking at these provisions and wanting to know how it may affect you from a professional liability, exposure, or coverage perspective. So that's all the time we have for today. I thank you for doing this racehorse look at the B101. In early June, we will be looking at A201 and the new insurance provision as part of that. I think what we'll be looking at is really how that language can affect a professional. I think it protects you fairly well, but you need to be aware of what's in not only like the A101, but the general conditions, the A201 as well. And again, I thank you for attending, and we'll look forward to any comments you have, and please check out our website.